Welcome. Namaste. Once again, welcome to our legal awareness series. Today we discuss a very important and sensitive issue. Can police, ED or any investigating agency summon an advocate to give a legal opinion in a criminal case, rather in connection with their giving a legal advice to clients? Can he be summoned? So generally investigation agency is having power to conduct investigation. That is some people they call it as a prerogative power, but generally speaking it is the court which is authorizing, and the code, that is Criminal Procedure Code or BNS Act, which is giving power or authorizing or giving power to the investigating agency to conduct it. The question is it legal, is it ethical, and what does the law say? So on this aspect, we are very clear that an advocate is a professional engaged by a client to give legal advice, and he appears in courts and defend legal rights. The relationship between an advocate and their client is protected by law, especially under sections 126 and 129 of the Indian Evidence Act 1872. These sections uphold the principles of advocate-client privilege, meaning any communication between a lawyer and their client is confidential. Like an advocate cannot be forced to disclose such communications or give opinions relating to matters of their client unless permitted by the client. So this privilege that is now being under the question or judicial review by the courts. The question is whether the answer simple and clear is no, an advocate cannot be summoned by the police or ED merely to give his act relating to his giving legal advice to clients, or is giving a legal opinion in connection with a crime or investigation. But according to the Bar Council of India rules, it is unethical for an advocate to give legal opinions to the any thing relating to legal opinions to the police officers. Likewise, the Supreme Court in various cases held like that. Agencies like Enforcement Directorate deal with financial crimes, money laundering, FEMA violations, etc. They are powerful under laws like PMLA, that is Prevention of Money Laundering Act, but even then they are not above constitutional protections. The Supreme Court in a famous case, Satish Kumar Sharma versus Bar Council of Himachal Pradesh, emphasized that legal professions cannot be harassed or used as tools in investigations. If you are an advocate and receives a summons to provide anything regarding a legal opinion or advice given by you to clients, you can politely respond in writing that legal opinions given to clients are protected by professional privileges. Rather, you can seek otherwise also for a legal assistance or approach the Bar Council. Or rather, you can move by way of writ petition under Article 226 of the Constitution to pass such illegal summons. The independence of the legal profession is the cornerstone of justice. Neither the police nor the ED has the power to compel an advocate to give any information relating to the legal opinions given unless the advocate is part of the investigation as an accused or a witness. But even when you are an accused or a witness also, can you be called to give anything in respect of your opinion given or advice given to clients merely because a summons is issued to you regarding that? So, in this connection, recently, that is yesterday, what has happened we have to see. The Honorable Supreme Court has suo motu taken up a case of the summons issued by the Directorate of Enforcement ED to senior advocates for their legal advice to clients. Even the case is listed before the Honorable three-bench, that is Chief Justice B.R. Gavai, Justices Vinod K. Chandran and N.V. Anjaria on July 14, the first working day after summer vacations. It is listed. Suo motu, this case is taken up. Why it is important and why it is taken up? The Top Courts Bar Association earlier written letters to Chief Justice of Honorable Supreme Courts on the chilling effect the summons had on the independence of the legal profession and eventually the entire justice administration. Arvind Dattar and Pratap Venugopal had written letters to the Honorable Chief Justices after receiving summons for their professional advice to client. Of course, first the summons are given and the later summons are withdrawn. But what happened later? Again on June 25, the top court, that is the Supreme Court, deprecated all these things and it said that any advice or help provided by an advocate to his clients, saying the practice would is the that they are entitled to give such opinions. If you say that for that, if you that is ED or police or any investigating officers summons for that, it has to be deprecated. The Supreme Court also said it is deprecating by saying the practice would imperil the autonomy of the legal profession. The court was, while dealing with a petition from Gujarat based advocate who was summoned by the police after securing bail for his client in a loan dispute case. The question is whether such practice is permissible. This is not just about one lawyer. Daily, lawyers' duty is to give legal opinions or advices or take up the cases and argue the matters in the courts. So, it is about protecting the legal system. Such summons are prima facie untenable, the court noted. But it is the matter is listed. What is at stake is the efficacy of the administration of justice and the capacity of the lawyers to consciously and more importantly fearlessly discharge their professional duties. The important thing there, the questions that arise are considered by the court is whether probe agencies could directly summon and question lawyers on the professional advice rendered to their clients. Even if the role of an individual, that is an advocate, was more than that of a lawyer, the court has asked if the agencies could issue summons or should there be some judicial oversight. So the important thing is there must be a balance. Suppose an advocate has committed a crime. That is a different aspect. But he simply had given a legal advice. When he has given a legal advice, if the police officers or anybody gives summons in that connection to give his statement regarding what legal opinion he has given, that is not permissible because, as earlier said, a privilege is there. So it is a burning issue. Let us hope and see on 14th of July, after opening of the Supreme Court, the matter will be taken up and it will be decided. In the meanwhile, what all I say is, in order to protect the legal profession, all the advocates firmly must fight for their rights, including the right of privilege, unless a client gives authorization to express anything regarding the opinions, to give some information to either the police officers or the agents. When such privilege is there, without the consent or the order of the court, they cannot be summoned.